Hello and welcome to yet another episode of Technocracy. I am Hina Goswami, editorial consultant with IGPP, Institute for Governance, Policies and Politics, New Delhi. In March this year, OpenAI's GPT-4 launched a new feature that allows users to recreate their pictures in an animated manner, in a style that closely resembles the animation art created by Ghibli Studio. This new feature thrilled the users, leading to the flooding of social media with Ghibli style pictures. However, it also reignited the debate about creativity, copyright violation, and if AI spells the doom for artists. Now, before we go into the larger debate, let us understand what triggered it all. The Ghibli Studio is a famed animation studio of Japan, known for its animation that even in this day and age is created by hand-drawn animation and has detailed backgrounds. So with GPT-4's new feature, the art that took long hours and years of training and talent to be created can now be replicated within seconds. Further, the founder of this studio, Hayao Miyazaki, is no fan of AI generated art. Of AI art, he is reported to have said, I am utterly disgusted. If you really want to make this creepy stuff, go ahead and do it. I would never wish to incorporate this technology into my work. I strongly feel this is an insult to life itself. Now, as the founder clearly expressed his distaste for incorporating AI into his work, the unveiling of the new feature has sparked debates as to whether OpenAI violated copyright laws, as the image generator is closely mimicking the hallmark animation style of the Ghibli studio. This is not the first copyright violation that the large techs are dealing with. There have been several controversies regarding the use of copyrighted materials as datasets to train AI models. In the USA, comedian Sarah Silverman and fellow authors sued ChatGPT maker OpenAI and Meta, alleging that her copyright has been infringed in the training of the firm's AI system. The case against OpenAI alleges that without the author's consent, their copyright material were ingested and used to train ChatGPT. Similarly, the New York Times sued OpenAI and Microsoft for the unpermitted use of Times articles to train GPT large language models. Actress Scarlett Johansson also accused OpenAI of using a voice for their AI assistant that is similar to her, despite her declining an offer to voice the AI herself. Closer home, the news agency ANI filed a lawsuit against OpenAI for alleged copyright violations. ANI says OpenAI used its news content to train ChatGPT without permission. The US Copyright Act, the Indian Copyright Act, along with international treaties such as the Berne Convention, grant creators exclusive rights over their original works, and creators must provide consent before their works are reproduced or adapted. However, there are certain principles of copyright laws that puts AI generated work into a gray area. For example, whether AI generated work is to be considered derivative or transformative. A derivative work is one that is recast, transformed, or adapted from an original work. On the other hand, a transformative work must add something new to the original work, altering it with new meaning, expression, or a message. The creation of a derivative work requires permission from the copyright owner of the original work, while that of transformative work does not. Further, copyright safeguards the expression of an idea, not the idea itself, a principle known as the idea expression dichotomy. This means that while a specific artwork, such as a painting or an illustration, is copyrightable, the broader artistic style or technique used to create it is not. There's also the principle of fair use doctrine, a legal principle in copyright law that allows limited use of copyrighted material without permission from the copyright holder. This use is permitted under certain circumstances, such as for purposes of criticism, comment, news reporting, scholarship, and research. At the moment, the originality and the legality of AI generated art remains a grey area, as none of the copyright laws around the world were originally designed to address AI created works. And most of the cases we discussed have still not been resolved satisfactorily. But the whole controversy surrounding Ghibli art also raises some important ethical questions. If AI can, in seconds, reproduce generations of hard work and training, what is the incentive for artists to create art? In this world of fast consumption, traditional art forms such as painting, decor, or craft were already under attack. And as Gen AI becomes more commonplace, artists tend to lose more than ever. As the situation stands today, marketing agencies and designing studios are already doing away with designers, illustrators, and simply prompting AI to create art that suits their needs. What will happen to those who are being displaced or who won't be hired? OpenAI CEO Sam Altman has defended AI generated art, saying it's not meant to replace artists but to help people become more creative. But would we tell our children to become painters, cartoonists, designers, and put years of training in it if AI is there to create and replicate everything? No matter how unique your style is, AI will mimic it in seconds. Furthermore, all those artists whose work was used to train AI, was their consent taken? Were they aware of the ways in which their art would turn into data that would be fed into an application that will creatively replicate the same for the use of others? Would they have said yes to such a proposition if they were aware? Lastly, the cost of generating AI art is not insignificant for the environment. The frenzy of Ghibli style photos was such that OpenAI was struggling to keep up with the demand, and as its GPUs were overheating, rate limits were introduced to restrict Ghibli style image generations. The question is, just because AI can create art, should it? To understand such questions and understand the legal and ethical implications surrounding AI generated art, today we are joined by Mr. Matt Blezisk. Matt Blezisk is a research fellow in law and mobility at the University of Michigan Law School and managing editor of the Journal of Law and Mobility. Matt's scholarship focuses upon intellectual property law, antitrust, contracts, and intersection of law and technology.